Imagine finding out your father died. Not from a phone call, not from a family member reaching out with condolences, not even from a social media post. You find out because a debt collector sends a letter to your house addressed to his estate. That's it. That's how you learn that your dad is gone. And then you discover he's been dead for 3 months. 3 entire months. And nobody told you. Not because they didn't know how to reach you, but because someone made sure they couldn't. That is exactly what happened to a 30-year-old woman in Florida, and her story raises some serious legal questions that anyone in a blended family, an estranged family, or really any family at all needs to hear. Let's back up and give you the full picture because the details here matter a lot. This young woman has been estranged from her father for nearly 11 years. Since she was around 19 years old, she has had no relationship with him. And this wasn't just a casual falling out over the holidays. Her mother had a restraining order against this man for the same amount of time. We're talking about a documented, legally recognized situation where this father was considered a threat. So the estrangement wasn't petty, it wasn't dramatic, it was serious, and it was protective. Now, her entire family on her father's side is originally from Canada. Her parents relocated to the United States when she was just a baby. She holds dual citizenship, her mother has a green card, and her father also had a green card. That international element is going to become very important as this story unfolds. When the family cut ties, they cut them completely. Her father's side of the family believed him over her and her mother, and so she lost contact with all of them. Her cousins, her aunts, her uncles, gone. One cousin in particular, who is also 30 years old, she hadn't spoken to in about 7 years. That cousin becomes a key figure in this story. So here's where things get really interesting and honestly infuriating. A debt collector sends a letter to this woman's mother. The letter is addressed to the estate of the father. That is how this family finds out he is dead. Not a phone call, not a visit, not even a secondhand message passed along through the grapevine. A debt collection notice. In the mail. The daughter reaches out to her estranged cousin and asks a question that should never have to be asked that way. Did my dad die? And the cousin confirms it. Yes, he passed away in January. And then comes the part that really twists the knife. The cousin says she wasn't allowed to tell her. She was specifically instructed not to reach out, not to say a word. And who gave that instruction? The new wife. Here's what we know about the new wife. She and the father got married in the same Florida city where our storyteller lives. They lived there together. The wife is also Canadian. The father died in a different city in Florida. The details of exactly how are still unclear, though it was described as an accident. After he died, the wife made the decision to cremate him, collect his ashes, and then move back to Canada. She is now across an international border with her late husband's remains. And the funeral? Barely anyone was there. No obituary was published. Nothing was posted online by any family member. It was as if this man's death was deliberately scrubbed from public record. The cousin confirmed this wasn't an accident or an oversight. It was intentional. The wife made sure of it. Now the cousin mentioned something that adds another layer of mystery to all of this. She said the wife instructed her not to tell the daughter for legal reasons. Legal reasons. That phrase is doing an enormous amount of heavy lifting here, and it deserves to be examined carefully. Because as far as most estate attorneys would tell you, there is no legal reason to hide a person's death from their biological child. In fact, in most states, including Florida, the opposite is true. Florida law requires that when someone dies, their estate goes through a legal process called probate. During probate, heirs and interested parties, and a biological adult child absolutely qualifies as an interested party, are supposed to be notified. Hiding a death from a biological child to avoid them participating in probate proceedings isn't a legal protection. It could actually be a legal violation. So what might the wife have been trying to avoid? A few possibilities stand out immediately. First, inheritance. If the father died without a will, or with a will that excluded his daughter, she may still have rights depending on Florida law and how assets were structured. If he died intestate, meaning without a valid will, Florida's intestate succession laws would typically include biological children as heirs. The wife may have been trying to close out the estate quietly before anyone knew there was an estate to claim. Second, and this one is significant, Social Security benefits. The daughter's mother brought this up herself. As a divorced spouse, under certain conditions, the mother could be entitled to survivor benefits through Social Security based on the father's work record. Those benefits don't disappear just because the death is hidden. But delays in filing can create complications, and if the wife was hoping the clock would run out on anything, keeping quiet bought her time. Third, there's the question of whether the father had any life insurance, retirement accounts, or other assets that named beneficiaries. If the daughter was never notified of the death, she couldn't contest a beneficiary designation or make any kind of claim. And then there's the international dimension. The wife has now moved back to Canada. She took the ashes with her. If there are assets, disputes, or legal claims to be made, pursuing them across an international border gets significantly more complicated and significantly more expensive. That might not be a coincidence. The emotional piece of this story is just as important as the legal one, and it deserves acknowledgement. This young woman said something that a lot of people in complicated family situations will recognize immediately. She said she isn't really sad. She's angry, she's confused, and she feels guilty that she isn't more sad. That guilt is something grief counselors hear about constantly from people who've lost estranged relatives. When you've already spent years grieving a relationship that was alive but broken, the death of the person can feel like a strange echo rather than a fresh wound. The mourning already happened in pieces over 11 years. So the numbness isn't a character flaw. It's not evidence that she didn't care. It's a completely understandable psychological response to a loss that was already processed in a different form a long time ago. But the anger makes complete sense. Because regardless of how she felt about her father, she deserved to know. She deserved to make her own choice about whether to attend a funeral, whether to reach out, whether to sit with the news privately or publicly. Someone took that choice away from her deliberately. That is a violation, even between estranged family members. Now let's talk about what this woman and anyone in a similar situation should actually do. Step 1 is to consult a probate attorney in Florida as soon as possible. Because the death happened in Florida, and the father lived in Florida, that is the jurisdiction where probate would have been filed, if it was filed at all. An attorney can search public records to find out whether a probate case was opened, what assets were included, and whether the proper notification procedures were followed. If they weren't, there may be grounds to challenge the proceedings. Step 2 is to contact the Social Security Administration. If the mother was married to this man for at least 10 years before they divorced, she may be entitled to divorced spouse survivor benefits. This is a federal benefit, not a state one, and it does not require the cooperation of the new wife or the estate. She should call SSA directly and ask about her eligibility. Step 3 is to document everything. The letter from the debt collector, the messages with the cousin, the timeline of when the death occurred versus when this family found out. All of it should be saved and organized. If any legal action follows, that documentation is going to matter. Step 4 is to consider consulting an attorney who has experience with international estate issues, given that the wife is now in Canada. If assets cross the border, or if the wife is handling estate matters from Canada, that adds a layer of complexity that a general probate attorney might not be equipped to handle alone. And step 5, which sounds simple but isn't, give yourself permission to feel whatever you feel. You don't owe grief to someone you were estranged from. You don't owe forgiveness. You don't owe peace. You do owe yourself the truth about what happened and the legal protections you are entitled to. The bottom line of this story is that hiding a death from a biological child is not just cruel. In many cases, it's legally actionable. Florida probate law has notification requirements for a reason. Those requirements exist to protect exactly the kind of person this young woman is. Someone who might otherwise be cut out of their own family's legal proceedings by a surviving spouse with something to gain from the silence. If this situation sounds familiar to you, If you've been estranged from a parent and you're wondering what your rights might be if something were to happen to them, or if you're in the middle of a situation exactly like this one, the most important thing you can do right now is talk to a probate attorney in the state where that parent lived. Many offer free consultations, and the clock on these things matters. Probate timelines are real, and delays cost people money and rights every single day. If you found this story eye-opening or helpful, subscribe to this channel. We cover real legal situations, the kind that happen to real people in real families, and we break them down so you know what your options actually are. Hit that notification bell so you never miss a new video. Because the law doesn't care whether you knew your rights. It only cares whether you acted on them in time.